Did you ever wonder what a real estate contract looks like? Well, in this episode, we're going to be going over the contract step by step, and I'm going to give you an exact template that I use to close wholesale deals. Let's dive in. Hey, and welcome back to another episode of the Believe Yourself podcast. My name is Greg, and thanks for tuning in today. If you're new here, please make sure you go hit that subscribe button and hit that like. And if you've been a long time subscriber, thank you for your support. So in today's episode, we're going to be going over the real estate contract that I use to close wholesale deals. This contract has been tweaked. It's been changed, it's been turned around, and I've added a few things to this contract to make it better. So let me switch my screen over and we're going to take a look at the contract now. All right, so as you can see on my screen, we have the contract here. All right, so what I'm going to do is I'm just going to zoom in just a little bit so you guys can see exactly what I'm talking about. So here we have our basic purchase contract and escrow instructions. Some people may not like the legal jargon, they may not be familiar, but this contract is pretty easy to understand. And what I've used when I don't understand something, I go to ChatGPT and I just copy and paste it and put it in there. And I say, tell me what this means in layman's terms, meaning like common English or whatever. So we'll go over what escrow instructions are once we get down to, further down in the contract. This contract and escrow instructions is effective as of the latest date and is executed by both parties, meaning the buyer and seller, and comprises the entire contract and agreement between seller and buyer, and which is the collective parties. All right, so the basic terms. This section 1 defines the basic terms of the contract. So you have to have the property address. So you put the property address here. Then down here, the APN stands for assessor's parcel number. So every house has a parcel number with a couple of numbers which shows like the county. It could be like the city, and then I have the parcel number for like the street and stuff like that. The legal description of the actual property. So we're going to go over that once we get further down. The property. So the property described in section 1.1 and 1.2 together with all improvement fixtures, apertures. So 1.3 the property. So this is what's on the land. So the house, anything that's affixed to the house, including like timber rights and things of that nature, which would be included in 1.3. What is earnest money, also called the EMD? So earnest money is a good faith deposit stating that you're serious about actually going forward with the deal. So you're not just kind of kicking the tires and just kind of window shopping. You're really telling the seller that I'm really interested in this property. So right below that, you have the purchase price, which you agree to. Then a close of escrow date, meaning the date of close. When is everything going to be finalized? You did your due diligence. You did an inspection. You liked everything. You have gone back and forth, and you want to close on like the 30th of March or something. So the escrow agent here could be a title company or an attorney, and they're a neutral third party just to make sure both sides, both the seller and the buyer, are performing under the contract. You know, they'll kind of update each other on what's going on. Hey, I need this. I need this from you. You didn't send this in, and they'll just make sure that everything is done. And they'll also be running the title search on the property to make sure there's nothing, any liens or encumbrances on the property. So when you do go to closing, everything is clear and everything goes through. So then you have the company name here, the address, escrow officer, all that good stuff. So the parties, you have the seller here who's selling the property, and then you have the buyer who's buying the property. Inspection period. Now, typically with inspection periods, they say around 14-day inspection periods, but depending on the type of property it is, you may ask for longer. I know in my deals, I usually ask for a 30-day due diligence or inspection period. And, I've done it as soon as, when we need a 7-day, and we got it done in 2. It all depends on the type of deal. Some commercial deals, they allow 90-day inspection periods, because if it's a huge apartment complex, there's no way in 15 days you can be able to get access to each apartment, go through everything. So it can happen. So now you have 1.11, the closing amounts to be paid as follows. So depending on the type of deal and conditions that you and the seller come up with, you being the buyer, it'll be, you can split it down the middle, 50-50. You can pay all of the closing costs and escrow fees, or the buyer can pay all of the escrow and closing fees, or the seller can pay all the escrow and closing fees, depending on the type of deal. It all depends on the type of deal and conditions that you guys come up with. So personal property that can be included in the sale, all items attached and fixed to the property as to be effective with the following. So you can put that right down here. Contingent, can you leave the Porsche with the house? or can you leave the boat with the house, things of that nature. So you can put that in the contract as well. And then right below that, any additional terms and conditions. Then both the seller and the buyer would initial at the bottom here. Then to 2, purchase and sell of the property. So for number 2, the purchase and sell of property is, this basically says that you and the seller are agreeing to go into contract and you're gonna buy the property from the seller with everything that states in the contract. So number 3, the status of title. This in regular English says once the agreement has been made, the title company will put together what's called the commitment and give all the specification on what's needed to close and to get a clear title. So number 4, inspection and access to the property. It states that the buyer has the discretion to cancel this contract through written notice to the seller at any point during that inspection period. That's why it's so important to make sure you do your inspection, you look at the property. Also, it states that the seller will give access to the buyer or any prospective buyer, the end buyer, so they can inspect the property. Additionally, I added in here a hold harmless clause for the seller to protect them, just in case during the walkthrough any potential buyers would trip and fall, hurt themselves, anything like that, or even die, that it would hold the seller harmless and they can't be sued. So we're going to go down to number 5. So instructions to release a deposit upon cancellation during the inspection period. This is very important because what happens sometimes, or instances to where you need both the seller and the buyer to agree to release the earnest money deposit. So it states that the seller hereby irrevocably instructs escrow agent to return the deposit to the buyer or to any person or entity designated by buyer to receive the deposit if buyer elects to cancel this contract during the inspection period, and no further written instruction are required for escrow agent to release the deposit to buyer or to any person or entity designated by the buyer to receive the deposit. Seller hereby waives any rights under state or other law to object to the release of the deposit if the contract is canceled by the buyer during the inspection period, and waives any right to provide any additional written consent to the release of the deposit if the contract is canceled by the buyer during the inspection period. Now, like I stated before, it's very important that you have this clause in here so you don't have any issues, because if the seller doesn't want to release the $100 EMD, it's just tied up. There's nothing that the title company or closing attorney can do and say, well, both parties have to agree. By having this contract from the beginning, when they sign it, by having this in the contract from the beginning, when they sign it, they're already put on notice because they should have read what was in the contract. All right. So number 6 is the lead paint disclosure, which has to go in the contract. So any house built before 1978, the seller shall notify buyer of any lead-based paint. Right. So number 7, as is purchase. So if you're buying this property as is, usually in wholesale, you're buying as is. They don't have to fix anything up. They don't have to make any repairs. So number 8, escrow, close of escrow, which is COE, closing costs and proration. So basically, this states that the seller and buyer are hiring an escrow agent to handle the paperwork, money, and all the other tasks to finalize the deal. The transfer of the title will be done by a warranty deed, which guarantees that the title is free of any issues. So the buyer and seller shall execute all documents, perform all other acts. That means that they're required to have any paperwork and sign any documents that they need in order to get to closing. So where it says all real estate taxes, rents, assessments are prorated, so anything up to the closing date must be paid by the separate party. So whatever they're responsible for, that's what they have to pay for. And then whatever you guys agree to. So if the buyer's paying on closing, you're paying on all closing fees. If the seller's paying half a closing, you're paying the other half. That has to be done. All right, number 9. So if any party fails to comply or perform under the contract, they have to deliver a notice of breach specifying the non-compliance. So the seller refuses to close because they find out that you're wholesaling the deal. You have this deal under contract. So if they refuse to close, depending on, let's say your assignment fee is $100,000, is it worth you going to court over that $100,000? It all depends on you. So a written notice has to be sent. If the non-compliance is not clear within 10 days after receipt, that is considered a breach of contract. A cure notice is not required upon seller indicating an intention to or refusing to close escrow by close of escrow date. If the seller shall breach any of the terms or provisions in this contract, buyer may proceed against seller for any claim or remedy to the buyer. It may have in law or equity, which includes but not limited to specific performance and damages. So like I said, if you had potentially the ability to make a certain amount of money from closing this contract, then you can take this to court. Number 10, no oral changes or representation. So any changes that you may want to make in this contract needs to be done with an addendum and not calling on the phone or anything like that. It has to all be written and signed by both parties. Any notices have to be sent by, it could be email. You can give it to the person, which I don't recommend giving it to them directly. I recommend either doing US mail, which says on here registered, or certified mail, because it has tracking and they have to sign for it, or if anyone over the age of 18 accepts it. So number 12, miscellaneous, like the addendum. These are where you want to make changes to the contract. If you want to add something, you want to take something away, assignment, the buyer should have the right to assign this contract. And this is an important piece to have in here. So they can never say you didn't tell them that you were assigning the contract. Buyer's marketing of his contract interest. This is basically you saying that, you're going to basically shop it around, saying like, hey, I got a house over here that has this much potential ARV. It needs this much to get fixed. You can put it up on MLS. So it gives you the ability to do that. Time is of the essence, meaning that they can't drag their feet to get to close. They can't do anything to prevent getting to close. Choice of law is usually whatever state that the property resides in. Memorandum of contract, that's something that you can execute. You take this assignment contract and a memorandum contract and you go down to the county and you record that, stating that you have an equitable interest in the property. All right. Electronic execution and counterparts. This contract may be executed by electronic means and in any number of counterparts, each of which shall be deemed an original, and all of which, when taken together, shall constitute one instrument. All right. So usually I send my contracts using DocuSign. And then the buyer disclosure and voluntary agreement. Seller understands, acknowledges the buyer is a wholesale buyer. Now you give them notice that this is what you're doing. You're not keeping it a secret, which means buyer is an investor who, in its discretion, may assign the contractual interest in the property for a profit. The purchase price may not reflect the property's fair market value. So down here, you have the seller and buyer's acknowledgement where both people would sign. The persons will sign the contract down here and then they would initial. So that is the basis of the purchase agreement when you're doing a wholesale deal. I know this video was a little long because I wanted to get through a couple of the points. I actually kind of went in a little further with the contract. If you click the link down below in the description, you'll see a link to where you can get a copy of this exact template. If you like this video, you found it to be of use and it gave you some knowledge on the real estate purchasing agreement, please make sure you subscribe, you hit that bell so you get notified when I post new videos, and you share this with 2 people. I appreciate you. Hope to see you in the next episode. Take care.